be a little difficult to tune in during the day if you're working still or have young kids or whatever it might be. So this evening session is more geared towards reaching out to all of you and hopefully addressing a lot of concerns that you all have. Specifically today, we're going to be talking a lot about protecting your family members from a lot of different sort of concerns you might have, whether it's liabilities or substance abuse issues or anything like that. There's a lot of things you can do through an estate plan to protect them sort of from themselves and from others. And we're going to talk about a few key ways that your estate planning can help them out there. It's really important to also be aware that, a good estate plan will have backup tools and, sort of built in so that even if you couldn't have foreseen some of these issues coming up, you have certain things to take care of them, just in case something goes wrong. It's really important to make sure that no matter what happens, you have the right tools in the toolbox, right? You wouldn't want to necessarily walk in to build a house and only have a hammer. It would help you out with one part of that, but it would not help you out with everything. You want to make sure that you have all of those tools. And even the most responsible beneficiaries, responsible kids in the world can still need protection. It's not always something that they're responsible for. It's not always something that's their fault. Bad things happen to good people, right? Sometimes. So it's something that you want to keep in mind. Hopefully none of this ever happens, right? Hopefully nothing ever goes wrong and your beneficiaries never need that protection, but it's important to make sure you have it built in. So that's going to be our main topic today. The various sort of mechanisms we can use. We have a couple materials for you all. We'll be kind of walking through them. And if you've registered today, you'll get those as well. Registered through Zoom, I should say. You'll get an email with the materials in it afterwards. So welcome, everybody. I'm Attorney Justin Randall with Hooper Law Office. Welcome on our evening edition, to our evening edition of our webinar series. Today, in particular, what we're going to be talking about is our, how to protect your loved ones through an estate plan. There are a lot of different reasons you might need to protect someone, whether it's, maybe they're not the most responsible beneficiary in the world. Maybe they don't handle money all that well. Maybe there's a substance abuse issue, or maybe you need to protect them from others. There's a lot of, bad things that happen to good people, otherwise responsible people. Sometimes there's a lawsuit that might come up, or one of the more common things, a medical bankruptcy. It's one of the most common causes of financial duress in this country is a medical bankruptcy. So even otherwise responsible people may still have those types of liabilities coming up. Another thing is divorce too, is a common concern that people have for their kids, and they want to make sure that what they leave their children is safe from that potential risk. So what I mean by protecting someone through an estate plan is, during your lifetime, you're not necessarily protecting them with that estate plan, but what you are doing is you're making sure that if they were to inherit from you, that inheritance is protected for them or protected from them. Like I said, if they're irresponsible or if they have those substance abuse issues, it doesn't mean you don't want them to benefit still. It doesn't mean you don't want them to be taken care of. It just may mean that you don't want them to be in charge. So that's actually where the two handouts that you'll be receiving if you, if you signed up via Zoom, that you'll receive via email after this is over. We have a little chart about protecting loved ones from others, and then also protecting loved ones from themselves. And just as a reminder as well, if you did sign up for this via Zoom, you're not just watching it on Facebook Live, there are evaluation forms you'll also be receiving. Those are helpful if you can fill them out. That just lets us know, if there's any topics you'd like us to hear or like us to teach to you, or any sort of feedback you have that can help us improve the process or the presentation or whatever it might be. That's really helpful to us. So that's one use of those. Another is if anything today raises any concerns for you and you would like to come in and talk to one of our attorneys, myself or any of the other attorneys, you can put on that evaluation form that you would like us to reach out to you and set up an initial consultation. Those consultations are complimentary. We schedule them for about 2 hours. They, give or take, they may take a little longer or less depending on the situation. But we encourage you, if anything I talk about today raises concerns or things kind of hit home for you at all, I would definitely encourage, fill out that evaluation form, say that you would like us to reach out to you, and then we will. If you don't want us to reach out to you to set up an appointment, you don't have to fill that part of the evaluation out. But if you can still fill out the evaluation part of it, of what you thought of this presentation, then please do. It is, like I said, very helpful. So kind of getting into the meat of everything here. And I should actually remind you as well, if any of you have any questions, I can actually see the questions come up in a Q&A box. So you are able to submit them. If you're participating via Zoom, I can see them. So if anything comes up where you want to interject with a question, please do. I'll try to get to it as quickly as I can. Screen's a little far away, so if I lean in and squint, that's why. It's not because I'm trying to get off camera for you. But to get started, one of the biggest concerns that people have when they're talking about leaving things to their kids is sort of protecting the assets they leave them from other people or other problems. We're not talking as much about the irresponsibility here. We're talking about maybe there's financial concerns they have through a bankruptcy that's going on, and if they were to inherit all of a sudden, that could be an issue. Maybe it's you really don't like your child's spouse, and you really want to make sure that under no circumstances can they get any part of that money through a divorce, through a commingling of the funds, through any sort of potential catastrophe that could happen. You don't want it to go to that son or daughter-in-law. You just don't. That's not what you want to have happen with your money. So those are a couple of things that you can protect from people. Another, believe it or not, is actually long-term care expenses for your child or your beneficiary, I should say. It does not have to necessarily be a child here. When somebody inherits with the proper mechanism, as long as it's set up the right way, the assets they receive may not be available for their long-term care expenses should they need that care at some point. So, when it comes to qualifying for Medicaid, going into a nursing home or an assisted living facility, the assets they receive through your estate plan, again, assuming it's set up properly, it can be safe for them. And that's incredibly beneficial, because it's money then that they have available to supplement their care going down the road, even if they run out of their own. So that's a really big thing, and I've actually seen that work. But talking about a bankruptcy a little more, that's something that a lot of people don't think is going to be a huge issue, or well, my kid's responsible, so it might not happen. They budget well, they're really good at investing, so I don't think it's going to happen. But as I mentioned earlier, medical bankruptcy is a really big issue in this country, and it's one of the leading causes of bankruptcy. Last I checked, it was anyway. Who knows, that may change over the years, but currently that is. And the issue is, that can happen to the most responsible people in the world. If you have a sudden health event where you can't receive funds anymore, or because you're in a bankruptcy and now all of your money has to go to pay off that bankruptcy, or a lot of your assets do. Well, if they're in the middle of that bankruptcy when that happens, it's possible, if that inheritance just goes to them outright in their own name, that then just has to go directly to whatever the creditor is to pay that off. So, you may have not foreseen that being an issue, because it's, they were otherwise responsible. But it just goes to show you that these are things you want to account for, even if you don't think they're going to happen. Because the off chance that it does, if you don't have the tools you need, your beneficiary is unfortunately not going to be protected anymore. And that's a huge issue. So whether it's an issue that you know about in advance, or an issue that you are just concerned could come up at some point, that's where you want to make sure that your estate plan is drafted properly, whether you're using a will or a trust. Make sure it's drafted properly so that your personal representative, or the executor is a more common way that you might have heard it referred to, or the trustee of your trust, make sure they have the mechanisms and the authority they need to protect the beneficiaries from those other liabilities potentially. Speaking of liabilities, this is a really useful tool for beneficiaries in high liability careers. So doctors or attorneys, for example, right? They're high liability careers. And in theory, most of these people are very responsible otherwise. But if they got sued for malpractice as an attorney or as a doctor, medical malpractice, there's a lot of assets at risk. So these sort of asset protections that you can put on somebody's inheritance are incredibly beneficial to somebody in one of those professions, because it's one less thing they have to worry about being at risk should they ever have a situation like that come up. So, this is something you often want to look at when you're talking to someone with, a child who's a physician, or a child who's an attorney, or, a police officer. I mean, it can be a lot of different issues, or a lot of different careers that potentially have higher liability if something goes wrong. Whether it's their fault or not. So it's just something to keep in mind, that you can protect them from those things happening, or at least what you are leaving them. We also talk about protecting people from themselves too. And this is often a harder discussion for people to think about, because you don't want to, you don't want it to feel like you don't trust your child or your loved one that you're leaving assets to, or you don't want them to feel betrayed that you did it. And, I completely understand those fears that people have. I mean, it's not an easy thing to do, and it's not a situation anyone wants to be in. Everyone would love for their child, or whoever they're leaving money to, their loved one or their friend, they would love them to be, responsible, not have a substance abuse issue, or, not necessarily have a disability. I mean, it could be any reason. You don't want that to be the case. But if those issues do arise, or they are there, you want to make sure that their inheritance does not go to harm them in any way. This is particularly true with substance abuse issues. If somebody has a substance abuse problem and they just suddenly receive an influx of money where they are in charge of it completely and can decide, to do whatever they want with it, well, odds are somebody with a substance abuse problem is going to use it to fuel that substance abuse, issue. So it's not something that you want to just say, well, oh, well, I couldn't have foreseen this, or I knew about it, but I didn't do anything about it. It's kind of up to them. You don't want that to be, kind of throw your hands up in the air and give up on it. There are things you can do to put someone else in control of it. And you can dictate what that inheritance can be used for. There's a lot of these restrictions you can place on it. You can be as restrictive as you need to be. You don't want to be overly restrictive in some situations because of the problems that can, create for using that inheritance later, if it's overly restrictive. But if someone has a substance abuse issue or had one in the past, and you're just worried about, how they use that inheritance, you can put someone else in control of it. And you can say it must be used for, X, Y, and Z expenses, living expenses, or, it can be used for education. I mean, there's a lot of different sorts of guidelines, distribution guidelines you can put on that inheritance. So just because a loved one has that issue does not mean you have to disinherit them. Disinheriting comes up a lot as something people think they have to do in a lot of these situations of, my son or my daughter is irresponsible. I love them. I would love to leave money to them, but they're just not responsible, and I'm going to disinherit them because they're just going to blow it. Well, you don't have to do that. This also unfortunately comes up a lot in special needs planning. So children with special needs, a common misconception that people have is that you have to disinherit that child and you can't leave them anything, or they'll lose all their benefits. And while it's true that a lot of these individuals are receiving benefits, some form of government program or other means-based assistance, and by means-based, I mean their qualification for that program depends on how much money they can have. It's true that if you just put money in their own name, through an inheritance or through a gift or whatever it might be, it could and very likely would cause some sort of a qualification issue for them. This happens a lot with people on Medicaid and nursing homes too, for example. But you don't have to disinherit them. There are other tools available. A common thing with children with special needs is what's known as a supplemental or special needs trust. That is a special type of trust that you can have someone inherit, or you can set up for during their lifetime, that says, the assets within this trust are not available to be counted against them for these programs. And there's very strict guidelines on what the funds of that inheritance can be used for, so that it does not disrupt their benefits in any way. So it just goes to show you that, you know, you can still leave assets to benefit that child with special needs or that loved one who's on Medicaid potentially, and supplement their life in a lot of ways, make their lives a lot better without also causing them the issues of a disruption to benefits. So benefits are not really a protection from others or from themselves necessarily. It's sort of its own thing, but it goes to show you can protect those benefits for them. You can protect their their lifestyle and their support, and make sure that it's even better than before because you're supplementing it through that inheritance then without causing them additional problems. Getting back to a little bit about protecting from others, one thing I'll add is with divorce, in Wisconsin, in a marital property state, in theory, inherited assets are individual property of the spouse that inherited them. The issue, though, so what that essentially means is not necessarily subject to division upon divorce. Not necessarily. It could be, though. And how that tends to happen is if somebody just receives, say, $100,000 from a parent or a loved one, and then they put it into a joint account, it gets very hard to tell, if there's ever a divorce of, okay, what is still individual about that? Is any of it still individual? Is only that initial 100,000 still individual? What about the interest it might have gained? So it really just opens it up to a lot of potential sort of what they call commingling of individual property with marital assets. So in theory, although even if somebody just left me an inheritance in my own name right now, and I was married, and then just suddenly got divorced, it would still be individual property as long as I kept it separate and was very careful about it. But there are better ways to do that if divorce is a concern, or that's even a sort of a maybe never will happen, but it's still something you want to protect against. There are provisions you can have in somebody's inheritance that say, okay, it's inherited in this trust. For example, they receive a trust from you, and it's kept separate. Then they can't add funds into it, so that as long as they keep the funds in that trust, it's never going to become marital property. So there's a lot of that protection there for them. I've already talked about high liability careers, medical bankruptcies, things like that. The biggest issue with protecting someone from themselves, like we said, is, substance abuse issues. Really, that's where, and it's not necessarily that person's fault, right? We're talking about they have a health issue, and it's something that they have difficulty controlling. So if you don't put those added protections on there for them, you're not necessarily helping them in any way, whereas there are the right ways to do it where you can help them. Another thing where we talk about protecting people from themselves is simply somebody's young, for example. This is a really big one. Almost always, the age restriction that I'm putting on somebody's plan for how old someone can be and be in charge of what they receive from that loved one through that estate is usually no less than 25 years old. You can legally inherit assets from an estate at age 18. That does not mean you should be in charge of it, though. As many of us are aware, and myself included on this, when we were 18, money was treated a little differently, possibly. And you may have not used it the most wisely that you could have, or invested it or saved it. You might have in college used it on a couple things that maybe, were, going out with your friends to the bar, right? I mean, that's not necessarily the smartest way to use an inheritance, to blow it on things like that. But it's really also not young people's fault. They're just not mature enough yet to deal with it. I mean, there's that common statistic that gets cited a lot that, well, nobody's really fully matured until they're age 25. That's when their, critical thinking skills and all of that is really sort of developed fully, hopefully. So, an 18-year-old just isn't able to make the same critical, decision that maybe a 30-year-old would make or a 35-year-old would make. And 25 is by no means something that, it's 25 or else. You can go as high as you want. I had somebody, their kids were all older than this, so it didn't really matter, but put, 45 on there. So it would have been along the lines of, well, okay, this isn't going to impact your kids, but it might impact the grandkids, right? Okay, so the grandkids can't inherit be in charge of any inheritance until they're 45, should that ever go down to them. So, you can really do as much as you want with that, or as little as you want, but I would say the minimum you want on that is about age 25, just because of impulse control and making sure someone handles the money properly. As Foss Hooper, the founder of our firm, would say, it's not a matter of, if they'll buy a Corvette, it's a matter of what color it's going to be. So you just want to be careful, just leaving money to, even a young adult without any sort of restrictions on it or protections there. If you leave assets to a minor, there's some added things that will need to be done, because a minor technically can't own property yet. So there's certain, like UTMA accounts you might have heard of, or UGMA accounts. I mean, there's certain types of accounts or custodial accounts that need to be set up for that individual, and those can be a hassle to deal with. So there's better ways to do that planning if you really need to leave assets to a minor. It's just easier for the person handling the funds, I should say, not necessarily. The minor themselves may not understand the difference, but it's really helpful to the person in charge of those funds. Another thing that often gets overlooked when we're talking about sort of protecting your loved ones is not the financial side of things, right? What about the sort of more personal side of things, the more personal aspects of planning that, especially if you have younger families? This is a really big one. I mentioned minors inheriting money can be a huge problem because of the fact that they're not allowed to own it yet. It doesn't mean they don't get it. It's just there's more restrictions. But it's not just the money side of things either. If you have minors, one really just critical and absolutely necessary thing that you need to be aware of is you have to name guardians for them if you want to have any sort of say over who sort of steps in if you and your spouse are gone, or if you're a single parent, if you're gone. So it's critical to name guardians in a couple of places. First and foremost, guardians after you've passed away, you must name in a will. You have to name it in your will. I've seen not too many examples, thankfully, but a few where somebody tried to name a guardian, a permanent guardian for somebody in a trust, and that's not where that is handled. Guardians must be approved by the court. So it's when you have a will, that must be administered by probate or through the probate process. So that's where the court will then make that, approval or denial, depending on how fit the nominated guardian is. But that's one place that you want to look at naming a guardian for permanent guardianship after you're gone. But there's also something to keep in mind, temporary guardianship. So, you may have guardians in your will for your minor children if something happens to you and your spouse permanently. But what about temporarily? What about if you are in a car accident temporarily and say a medically induced coma, both you and your spouse are, no one's there to take care of the kids, who has the authority to make temporary decisions for them until you recover? That's where you want to look at, in a financial power of attorney, naming a temporary guardian for them there. Often it may be the same people as the permanent guardians, or maybe it's different. Maybe your permanent guardians that you named in the will are further away location-wise than you would like them to be for a temporary position. So you maybe name family, friends, or closer relatives for the temporary position. You want to make sure you're making it work for you properly and making it make sense for the kid's life and your life and all of that as well. There's no right or wrong answer there. As long, the only wrong answer is if they're just not a trustworthy person, right? You don't want to have a non-trustworthy person be, or an untrustworthy person be a guardian for a child. So those are really two things to keep in mind when you're looking at protecting children, especially young children. Back to the financial side a little bit. There's a certain type of protection that people don't often think about when they have maybe children with sort of age gaps, maybe larger age gaps, maybe smaller age gaps. It can depend. If say you pass away and your loved one is, for example, or excuse me, beneficiary. I don't know why I said loved one. Your beneficiary is, say, the oldest is 22, but the youngest sibling is maybe 16. Well, if that 22-year-old inherits the same amount as the 16-year-old at the same time in separate shares, well, that means that 16-year-old does not have to spend that money on their own, raising themselves anymore. They're adults, they're out in the world, they can spend it on whatever they want. But that 16-year-old didn't receive the same amount of support from you growing up because they are a lot younger. So there's financial planning you can do in an estate plan, whether it's a will or a trust, where you set up something that says, all of my children's inheritance is sort of kept as under a single umbrella fund, what's often called a common trust, that does not split up individually for them until, a set period of time passes, or until the youngest reaches a certain age, or sometimes graduated from college is one that people put on there. That way you're making sure that even the youngest has received the same sort of fair level of support and maintenance growing up that the oldest did. It's not necessarily planning that you need to do for everybody. It might be, might not make sense for some families, but for a lot of families it does. And I would say probably 90% if there's at least even a couple year age gap between their kids. And so I did just get a question, is this information regarding guardians in today's handouts? And it's not in today's handouts. There's a couple of things that are available through our website that would give you some good information. And there's maybe something that we can try to include in that as well. I'll take a look at it and make sure that if there's something we can include in there, that we can push it out as well, or send it out in a separate email, or give you a link to the website where it is, or part of our website where it is. But yeah, it's important information to keep in mind. Another question, I have remarried and we both have children from a previous marriage. Is there anything special that we need to do? How do you make sure your ex can't access the money you leave behind? This is really common, especially these days. Blended families are much, much more common than they were, 50 years ago, right? So this is really common planning that comes up, or a planning issue that comes up. So it's kind of a two-part answer to that. How do you make sure that the ex has no right to it and no way of accessing it? Well, you make sure that you say that if you have that concern, that ex-spouse or ex, boyfriend or girlfriend or whoever it is, the ex is by no means under any circumstances allowed to be the trustee of it, or the guardian of it, of the funds, or usually just the trustee of those funds, right? You don't want them to be in control of it in any way. A way around that, a way of making sure that they aren't on top of that, is you specifically name someone else that you trust to control the funds for your kids. Whether it's your new spouse, or another family member, or an independent third party. There's a lot of options, but first and foremost, I would both say that ex-spouse can certainly never be in charge of my children's inheritance, and I would go a step further and say I'm going to also take the step to nominate somebody else too. And then there's also, with remarriage, and especially if you and your new spouse brought in kids previously, or each from a separate marriage, there's a little bit more complex planning with that, where if one of you passes away and you have joint planning, you might want to make sure that there's some provisions in there that say, a certain amount is sort of set aside where my surviving spouse can still utilize the income from it for the rest of their life, and they're still the lifetime beneficiary of it, so to speak. But ultimately, the one thing the surviving spouse cannot change is who the ultimate after death beneficiaries are on that sort of set aside amount. It's something you can do to make sure that no matter which one of you passes away first, whether it's you and you want your kids to receive something, or it's your spouse and the spouse wants their kids to receive something, there's good provisions you can put in there that say, basically, no matter who it is that passes away first, the first to die, their children are entitled to, X percentage, or, all of the individual property and X percentage of the estate after the second spouse passes away. there's, there are some things you can do where some people will leave money to their children right away and sort of circumvent the surviving spouse. That can raise other issues, not necessarily for the children, so to speak, or for tax purposes as much. It's really more, depending on the age where the first spouse passes away. If you're at a long-term care age where you're looking at one of you or the surviving spouse potentially needing care at some point, in Wisconsin, if you sort of circumvent the spouse and essentially what Medicaid would look at it as is disinherit the spouse, that's can cause a penalty for Medicaid. So if they're in a nursing home and receiving assistance, that may disrupt that assistance. So you just want to be careful about how you do it, but there are plenty of ways you can ensure that your children still receive at least a portion of the estate, or the fair portion of the estate, at least after the second spouse passes away. And potentially, depending on the situation, maybe upon the first death. Although again, like I said, you want to be very careful doing that. It can be very complicated to do blended family planning just because of not necessarily having the same biological children and having maybe more concerns about what happens if my new my second spouse now remarries after I pass away. How do I make sure my kids are still taken care of? And the best thing you can do in that situation, if you guys have that concern at all, is talk to an estate planning attorney. Honestly, come in to you can come in and talk to us. You can go to anyone you want, but you can definitely come in and talk to us about it, and you can kind of lay out the situation, and any one of us here could give you good advice on that of how to best set that up for your situation. So I know that's kind of the 1,000-foot view there. It can get really complicated, and in order to give you a really good answer, I'd need maybe an hour or so to look through a lot of different information, but of yours and your spouse. But hopefully that helps a little bit. Like I said, it's very common these days. So it's actually a really good point. It's a really good point of protection, right? It's different from protecting someone from others or themselves as much as it is sort of just protecting them from the circumstances of you want to make sure that your wishes are followed for them and that they receive what you would like them to. So I am running close on time here. I am getting some information from our marketing director that if you have questions on guardianship, if you want to email or call us, so 920-993-0990 is the phone number, or learn more at hooperlawoffice.com. So learn more at hooperlawoffice.com, no caps, anything like that. And we can try to get you the info that you're looking for guardianship and the sort of maybe like an information pamphlet that we have, or little booklets that we have, anything like that we can help get you the right information. Or if you'd like to come in and talk to any of the attorneys here, that's certainly something you can do as well. But if there's it doesn't look like there's any other questions. So thank you all for joining the not the inaugural webinar of Hooper Law Office, but our inaugural evening webinar of Hooper Law Office. This is something we're looking at doing for a couple of different topics as well. So to try to meet the demand of people who are still working and have kids, and the daytime is really busy. So please join in the next time. And just as a reminder, one more time before I sign off, if you do receive those evaluation forms from us, whether or not you would like an initial consultation, please feel free to fill out the evaluation forms. I promise I can take criticism well if there's anything I can improve on. And if you do want an initial consultation from us, or us to reach out to set one up for you, you can fill that part of that form out as well. We won't reach out to you otherwise. You can always reach out to us on your own too. That's always fine. We just won't reach out to you unless you fill out that aspect of the form. And as a reminder, those are complimentary consultations. It's not going to cost you anything to come in and talk to me, just because it's really hard to do proper planning for someone without knowing all the information first. So it doesn't do you or me any good if you're sort of afraid to come talk to us because of a paywall of any kind. So again, thank you all for joining our evening session here, and I hope you have a good rest of your week, and join us next week where we'll be talking about veterans a little bit, I believe, for veterans. Yeah, Veterans Day is coming.